Hello, America, and other countries that will soon be part of America. Coming to you from the left, I'm editorial cartoonist Ted Rall.
And I'm editorial cartoonist Scott Stantis, coming to you from the right. And we have, Ted is a little out of practice. He's been on vacation. You can tell he's tan, rested, and ready, coming back from his undisclosed location. It could have been Antarctic. It could have been Florida. It could have been Delaware. We just don't know. And neither do you. And neither do you, the United States of America government, who track such things, apparently.
Well, no, more than apparently. I don't know if did you follow how the Trump administration purchased all of the flight data from all of the airlines. And so they now have every airline reservation, historical and future, with your name, where you went, what flight you were on, what credit card you used, etc.
They bought it?
They bought it. Yeah, like basically the airlines they own this thing, this conglomerate that controls that kind of information, and they bought that information from the airline consortium, and and obviously they will not use it for anything bad, except it's going to ICE and the Department of Homeland Security. Our favorite people who never do anything thuggish or fascist.
No, we love them as our own children. We truly, truly do.
As our own fascist children.
We, our own little fascist children. Yes, our own little goose-stepping babies. Listen, we've got a guest coming. I hope he's coming on.
Here. He's in the wings. We should introduce everything first.
I'm going to introduce him. And this is Ted. Ted, I'm not sure if you ever met. I don't believe you ever met Ricardo.
I do not think
so. The way
so.
I met him, he lived around the corner from me here in Hoover, Alabama. At the time, and his kids went to the same school. Bless you. And there he is. So let me give his background very quick. He's Ricardo Aparicio, graduated Juris Doctor degree, cum laude, from the University of Miami School of Law. He is a member of the Florida and Alabama bars, as well as the U.S. Supreme Court bar, which he was just recently inducted into.
Most lawyers do not get to do that.
No. He spent over 20 years as in-house counsel to the General Electric Company and is currently the president and CEO of Aparicio Professional Advisors, LLC, providing consulting services to the real estate and construction industries. Ricardo, thanks for joining us.
A pleasure. Thank you for having me.
Yeah. So yesterday, day before yesterday, I can't remember. Yesterday, Ricardo and I actually listened to the oral arguments in front of the Supreme Court because we're, Ricardo, what's the word I'm looking for? Dorks?
Yeah.
And we listened to, ostensibly, I assumed the debate would be over birthright citizenship, which they seem to gloss over very quickly. I'm guessing there's unanimous consent in the court that, it's in the Constitution. It was decided many years ago, but the discussion actually segued towards universal injunctions, and do other courts, lower courts, have a right to do them? Solicitor General John Sawyer for the Trump administration also went on to say that the White House may not recognize appeal court. He certainly implied it, Ricardo. Appeal court decision, injunctions. So, I mean, all of this, it's a lot to unpack. And as a member of the SCOTUS bar, we had Ricardo come in. Yeah, it's impressive, man. Listen, it's impressive. You graduated from college. That's impressive to me. So
you did it in 4 years. That's impressive to me.
Yeah. Well, he actually, may I brag on my friend Ricardo for just a moment? He also, Ted, graduated from a law school as he had a full-time job as an architect, and he had a wife and 2 children. All of them.
But does he still have the wife? Is the question?
Yeah, I still do. Surprisingly enough. Yeah.
Yeah, he still has the wife, still has the children, and now he has glorious grandchildren. And but I mean, all of that's super impressive. So Ricardo, unpack a little bit of what we watched or what we heard yesterday.
Right. So like you said, this hearing yesterday was not about the merits of the executive order. As you know, the executive order was issued, I think, on day one by President Trump, basically instructing the agencies, the government agencies, to implement policies that do not recognize children born in the U.S. of undocumented aliens. As you said, that seems to run contrary to the clear language in the 14th Amendment. It certainly seems to run contrary to the few U.S. Supreme Court decisions that have been handed down over the past 100 years or so. But regardless, they issued this executive order, and almost immediately the administration was sued in a number of jurisdictions, challenging the validity of the order. The problem is, as we all know, that these issues get a while to be worked through the court system. The way the court system works, especially the federal system works, you have to go before a trial judge. The case is presented. It may take a year, it may take longer for the merits of the case to be considered. The judge will then make a decision whether the law is constitutional or not. And then the other party has a chance to appeal it. Typically, they go before a single appeal judge or sometimes a 3-judge panel. And at that point, again, they have to argue the case, they have to present it. And the appeal panel, again, may decide that the law is unconstitutional, the executive order in this case. Well, at that point, the administration then has the chance to appeal to the entire appeal court. They call that en banc hearing. So the entire group of judges in that particular district might decide to hear the case. And again, that takes time. When the decision comes down, if the administration then loses again, then they have an opportunity to go before the Supreme Court. And if they grant certiorari, then the Supreme Court reviews the case and handles that decision. I think Sotomayor yesterday, or may have been Keegan, talked about 4 or 5 years for these things to work itself to the Supreme Court. Justice Roberts sort of jokingly challenged that and put the example of the TikTok appeal that worked itself to the Supreme Court. And so happened, as you know, Scott, that I was there in person for that hearing, because that was the day I was getting sworn into the Supreme Court bar. So I got to be there for those oral arguments in person. But whether it takes 1, 2, 3, 4, 5 years doesn't matter. You have an executive order that is affecting, in this particular case, thousands of people. What happens in the meantime, right? Whether it's enforced or not enforced, people are going to get affected by that executive order. So a tool that is often used, not only at the federal level, but also at the state level, is an injunction, where the affected party, the plaintiff, goes before the court and says, I got an issue with this new executive order. I think it's unconstitutional. But while we go through that entire process to eventually get to the Supreme Court and settle this, I want you to issue an injunction and keep this administration from enforcing the law. Now, injunctions are, and I don't want to complicate this too much, but injunctions are basically an equitable remedy, something that the courts allow in order to balance the inequalities that are not necessarily addressed by the law, right? So an injunction is an equitable remedy, right? And there are basically 4 elements to granting an injunction at any level, federal or state. Number 1, you have to prove before that judge that the likelihood of you prevailing in your case is substantial, right? Which in this case, the judges that were hearing this agreed on that they had a substantial chance of prevailing eventually before the Supreme Court.
Substantial. Can you define substantial? Is that
I cannot.
Does that mean significant or more or likelier than not?
I have no idea, Ted. And look, like Scott said, I have a Juris Doctor degree cum laude with honors. Okay, and I cannot define it. All right, is more likely than not, I would say. All right, but it's got to be a little bit more than that, right? Because again, you're ordering somebody not to do something that they wanted to do, and that somebody may be damaged by their inability to do that. All right. So in order to preclude people from just filing lawsuits that have no basis at all and then delaying what would be inevitable, the court says you got to have a case here. You got to have a substantial or substantial chance that you're going to prevail on the merits. Otherwise, we're not going to preclude this party from going forward with their particular action. All right. Then number two, if you're able to show that, you have to show that you, the plaintiff, the one that's asking for the injunction, are going to suffer irreparable harm if this injunction is not issued, right? Let's say in this particular case, the order not to recognize a newborn as a U.S. citizen, could have significant irreparable damage to that individual and to the mother that gave him birth in terms of getting medical aid, in terms of getting some governmental support, et cetera, and
avoiding deportation.
And being subject to deportation, right? So there's irreparable harm that could be caused unless, the plaintiff says, you stop this order from going into effect while we litigate the case. And then the third element is the balance of equities in terms of here. Is this, given everything that we know about this particular case, who's going to be harmed more substantially by an injunction versus not? All right. Is the administration going to be harmed more than the plaintiff if we issue this injunction? Right. So that's a balance of the equities that they consider. And then the fourth one is public interest. Is issuing an injunction in this particular case a matter of public policy or public interest that confers the court the need to act here. So that's basically what they were arguing about yesterday. And the underlying principle, which I don't think they gave enough airtime too, because they all are familiar with it. Everybody that's arguing the case and hearing the case at that particular moment are familiar with is this issue of what is it that the federal courts are allowed to do and what are they prohibited from doing. Of course, you got to look at Article 3 of the Constitution, and also you got to look at the judicial acts that Congress has passed over the years. And one of the principles in general is that the court can only decide and act upon the case that is before it. So if someone, a plaintiff, goes before the court and says, this particular law, this particular executive order is going to harm me personally, and I want you to issue an injunction, the court in general could issue an injunction as to that particular individual and could tell whoever has issued that order or enacted the law to say, as far as this individual is concerned, you cannot enforce this law or any action referring to this law until we have a chance to hear the merits of the case. Generally, the court cannot issue an injunction for people who are not before it, right? They cannot say, okay, we're going to issue an injunction against the government enforcing this law against Ricardo, but guess what? We are now going to make that injunction universal, nationwide. All right. I think Souter referred to it as cosmic. Okay. We are going to keep the administration from enforcing this executive order against anybody named Ricardo. And I'm just saying that sort of jokingly to illustrate the point, right? But they cannot say, in general, you cannot enforce it against anybody called Ricardo, because we have a claim Ricardo, and therefore we're going to extend it. Well, that has no basis. The law would say that it would have to be similarly placed plaintiffs, not just because of the name, but because of the situation. All right. Now, part of the complication is this goes all the way back to British royal times, where this evolved as what they call the Bill of Peace, right? Where somebody would come before the equity courts and say, I'm a farmer, and the king has implemented these rules, and it is affecting me, and it's affecting a lot of other farmers. Issue a bill of peace to keep the king from enforcing this against farmers. And the courts would do that, right? And maybe it would be potato farmers, maybe it would be farmers in general, but it had to have some commonality in terms of that. That, the argument was made yesterday by the administration, by General Sauer, that the Bill of Peace has been replaced in our jurisprudence by class action lawsuits. And the proper avenue would be for plaintiffs to get a class action lawsuit going on behalf of people that would be affected by the executive order. And under those circumstances, can the court issue an injunction, because it's now a certified class of people nationwide.
But didn't Justice Barrett kind of jump all over General Sauer about that very question, saying, are you implying that every person, all 50 states and the territories, would have to file a lawsuit? I mean, she kind of walked him to the edge of absurdity, where in order to establish standing, they would have to go from state to state, jurisdiction to jurisdiction. And I think that the Solicitor General sort of lost his way in that discussion, because I understood at the top his very short statement prior to the question period, where he said, people, and he's right, he's not wrong, where he's saying people shop for jurisdictions. If you're a liberal, you're going to go to San Francisco. If you're conservative, you're going to go to Texas or Florida to find a sympathetic court. But I did think Justice Barrett's, and she's getting holy hell on the right wing blogosphere this morning, because she had the temerity to question the validity of this administration's perspectives. Getting back to, so specifically the birthright citizenship, in my mind, again, was not really addressed. My assumption is, and I'm not a sci, we're not experts, but we do play them, in cartoons.
I get it.
But my guess is that and Rumble. Yeah.
My sense is that the entire court believed that this was unconstitutional. This was, and just sort of pushed it aside. No, would you disagree?
I didn't get that stance, because it's very interesting that Thomas and even the other conservative justices, Kavanaugh,
Alito,
didn't mention the merits at all. The only ones that harp on it were Kagan and Jackson and of course Sotomayor, who made a big deal of it. I think Sotomayor at one point told him, you lost everywhere.
Yeah.
But yeah, so, and the point on that is that you appeal the merits of the case if you lose the case, right? And you appeal it through the normal process, unless it's important enough and it's urgent enough that you do a certiorari after judgment, which is bypass the appeal process, go directly to the Supreme Court and says, this is of extreme importance to the nation, and we need you to hear the case, right? But guess what? The people who have to do that are the people who lose. And administration has shown zero interest of going that way. They're very happy with having this work out through the court system. I don't know if you ever heard of this, but there are some people, whether they are in a civil lawsuit or maybe a criminal case in New York or maybe Washington, D.C., that will use delay tactics to keep this from actually being here in the merits. I've heard that's happened a few times.
That can't, not in this country.
Once or twice, perhaps. Yeah.
Apparently, and has something having to do with an election coming up, things like that. Anyway, so they seem to be perfectly happy to let this play out in the courts and to delay it as much as possible, because I think in their hearts of hearts they know that when it gets to the Supreme Court they're going to lose. But now, I did not get a sense from the hearing yesterday on how any of the other justices would come out. I mean, it's clearly that Sotomayor said it a bunch of times that this is wholly unconstitutional. It goes against our precedent. Likewise with Kagan and likewise with Jackson. But the other ones were less vocal about that.
So what
Ricardo,
about universal? I was just going to ask. Go ahead, Ted.
Well, I just wanted to, sorry, Scott, but I wanted to sort of say, so I'm so determined. Ricardo, this, when I think about, settled cases, things that are considered settled law, but yet get overturned, like Roe v. Wade, Dobbs decision, but that was long the reasoning behind Roe v. Wade, even among people who agree with abortion rights, has long been considered kind of a lot of people have criticized the reasoning, the privacy rights thing, the underpinnings of how the court arrived at that back in 1973. But is that the case in the Hong decision? The 14th Amendment that was basically had freed slaves in mind after the immediate aftermath of the Civil War to make sure that we understood that they were citizens. That is now viewed, because of this decision from 1897 or something, that says basically this Asian American went to courts and prevailed, and they said, clearly that includes basically if you're born in the U.S., you're born on the U.S. soil, you're American, period, and full stop. How is that decision viewed? Is it viewed as a well-reasoned decision that the Supreme Court would be loath to overturn, or is it vulnerable in the same way that Roe was?
No, I don't think it's vulnerable. What you have to understand, though, is that at the time of that decision, and this particular plaintiff, Wong, had been born in San Francisco, I think it was, had traveled to China. His parents were Chinese nationals, had traveled to China, had come back, no issue whatsoever, went back for a second time, and by the time he comes back, I think they already had passed the anti-Chinese immigration laws at that point. So he's denied entry back into the United States because he was, they considered not a U.S. citizen. The problem with that case, in essence, in terms of comparing it to today's situation, is that citizenship as such was not uniform in the United States. Right? Citizenship, funny enough, was a state-based. If you were able to establish residency in a place like California or Florida, right, you were conferred citizenship by being a citizen of that state. So each state would issue, as a matter of fact, different certificates of citizenship. So it was a patchwork.
And were there different standards to become a citizen in each
I think it became up to each state, whether the person was declared a citizen or not.
Really?
Up before a federal judge and all that kind of stuff. But it was a patchwork. It was very strange, right? Until Congress came in and passed the Naturalization Act, et cetera, et cetera. I think the particulars of the Wong case are relevant in terms that they clearly establish, according to the time, that this individual had been born in California, had been given citizenship by the state, and therefore was considered a U.S. citizen. So I don't think that will be litigated too much. I think what will be litigated, and that is what the administration, I think, has put its weight behind, is the subject to the jurisdiction thereof.
Let me jump in. And these seem like odd things to bring up, but they were highlighted in NPR's reporting of the oral arguments
Are
yesterday.
they still around? I thought we had taken out their
They are still around, interestingly enough, and they still infuriate people. But that's beside the point. They were reporting that Solicitor General says that the White House, and they did pull up the audio from the oral discussion, said that they may not, the White House may or may not recognize the appeal court injunctions. That's problematic. I mean, that is what you got to what.
Yeah, I know it's problematic when you have a branch of the government saying, "I'm not going to recognize some judicial order, even if the order says you cannot deport X, Y, and Z to El Salvador. We're going to ignore it. We're just going to do it."
Mm-hmm.
Yeah. Look, the reality is, I think in the context that, and Sauer's a very intelligent man, right? He's super bright individual. I think the gist of what he was saying, and I think that was the gist of the questions that he was being asked, again, because of this issue of how far can an injunction be issued. So I think the context of the question was, if the second district issues an injunction, okay, against you enforcing an executive order, are you going to recognize it for the Second Circuit, at least? Are you going to make sure that that order is not enforced within the second district? And of course, as every good lawyer, he's going to sort of couch his answer into, well, that's a hypothetical where you can answer. But in general, the practice of the Justice Department has been to respect and obey the injunctions within that district. And I think it was just saying it may be a case where we think the injunction is wrongly issued, or we're going to refuse to enforce it in that sense. So and I think it was Barrett who wanted a question on that, saying, you're really saying that, you wouldn't recognize it? And I said, well, in general, we would.
Oh, that's nice of them. And a real quick peripheral issue, and I noticed this, and this was reported, that the Department of Justice officials, 2 of them were sitting in the front row. The reason I mentioned that is that Sotomayor, you mentioned the little joke she made, and everybody laughed, and except for those 2. Is that, you said that you sat through arguments for TikTok, and I know, again, you haven't sat through a million hearings in front of the court, but is that unusual to send Department of Justice officials to sit in the front row and glower at the justices? It just seems weird to me, and very mafioso,
Yeah, I don't know who they were. I don't know what the role is. It's not unusual for the parties, both parties, to bring support staff with them, right? There's only, the Supreme Court space is relatively small. So there's not a lot of space at the bar, at the tables, for the parties to have significant people. I think it's 4, maybe. And I don't know how many people were there for each party, but it's not unusual to have other people there to be able to pass you a note, to be able to, cash something that maybe you didn't cash. That type of thing. So I don't know what the purpose was there. I rather doubt that they were there to intimidate the justices. Those justices.
Really? Because you don't think the Trump administration would do such a thing, or
no? Because I wouldn't do such a thing, because these people are not people that you can intimidate, right? I mean, you see Sotomayor. I don't know if you've seen her in person, but she's like, Jay High and elderly, and you could see that she has some health issues. I would not dare try to intimidate that lady.
There's no shits.
Yeah. These people are not ones to be intimidated, I don't think. So maybe they.
Ricardo, let me ask you this: is there a scenario in which the High Court, decides to rule against Trump on the 14th Amendment and birthright citizenship, and yet circumscribes the federal district court's ability to issue national stays?
No, I don't think so. Again, because the court cannot can only answer the issues that are before it. And there was a big point made yesterday, right, that the issue of the validity of the executive order itself had not been brought up to them. And to a certain extent, General Sauer was chastised by liberal justices for not bringing it up, right? Basically saying purposely you're not bringing it up because you're going to lose, right? So they cannot decide this on the merits of the case. So they have to have a narrow decision on whether national or universal injunctions are allowed and under what circumstances they should be allowed, or whether they are not allowed and the vehicle, well, they're not allowed under this context, okay? The only way they could be allowed would be through a class action lawsuit where you have certified a class of plaintiffs nationwide that are affected by this, and then a national injunction could be issued, which, again, Sauer sort of hedged against, saying, well, I'm not sure that, we wouldn't oppose this. He was talking out of both sides of his mouth, saying, well, the only way they can get a national or universal injunction is they certify a class, right? But at the same time, he was saying they didn't think they could qualify a class.
I understand. So why do you think the administration's attorneys decided to take, to look for this fight, right? I mean, on this issue of the national stays, why didn't they just sort of dither and dawdle and basically let the delays in the legal system fester while they're trying to carry out their policy? I mean, I know they kind of had good luck when they took an analogous gamble procedurally when they went to the Supreme Court and asked them to rule about the issue of the executive privilege, right? Whether the illegal crap that Trump did in his first term, whether it qualifies as something that he was immune to because he was serving as president. He won that. Shouldn't have, in my opinion, but did. Do they think, hey, we have the right, we have a court that's going to be sympathetic to us, and we can get this big sweeping decision that's going to help us in all sorts of other ways and expand executive power? Or is there something else or are they just focused on the birthright citizenship issue?
Look, I from what I heard yesterday, they have been hit with 40 universal injunctions, right? Which is an absolute record, but it's also an absolute record the amount of executive orders he has signed in the first 3 months. And to me, and even though nobody has addressed it, or at least I haven't found any articles that address it, the character of these executive orders are really, really pushing the envelope of the existing law and existing precedent. The enactment of the Enemies Act, right? The declaration of these gangs as a terrorist group. All of those things are pushing the envelope of what is allowed under the law. And they have been challenged on them, and they have received 40 injunctions, universal injunctions. So it's really, in their view, is tying their hands. They're not able to move forward on this. So what they want to attack is the concept of the injunction itself, to say, we are the executive power. Did we have, was it that Fidel Castro, or was it a U.S. president that says if the president does it, it cannot be illegal?
Both.
It was Ricardo Nixon, I believe.
Yeah. So which, by the way, that could be subject matter of a whole different discussion. But anyway, because it deals with executive power. But I think their position is, if we can get these people off our case, which, by the way, is something that the opposite party has used very effectively during Obama and during Biden in terms of getting national injunctions or universal injunctions against presidential executive orders. So if they can get this to go in their favor, then they have the freedom to continue to impose these rules and these orders without any restriction whatsoever. Now, Sotomayor had a great example that should send a chill down the spine of conservative voters, commentators, and Second Amendment rights proponents, supporters, which is, Sotomayor said, what if the president or issues an executive order and orders the military to go confiscate every private gun in the US? What is the solution for that? Right? Mm-hmm. It cannot be a national injunction, universal injunction against them, right? So while this works itself out through the court, they're going out there and taking guns away from people. It's clearly unconstitutional. And what is your solution? That just let it work out through the system? And Sauer, by the way, said a number of times, he used the word percolate, which is an interesting word. You need to let this percolate through the system. Yeah, it's a slow percolation that they want, but they want to have the ability in the meantime to enforce this, which the result would be, in my view, that then, which I think is the objective, people would self-deport.
Ricardo, are executive orders constitutional?
Yes, they are.
Why?
Well, first of all, because the great General Washington used them, and we know he could do no wrong. But no, as an executive, you have a right. Now, I'm going to ask you, Ted, because I don't know you well enough, but I know my friend Scott Stantis. I want to ask him this question, which is going to be a softball for him.
Okay.
Who is the guy before modern times that broke the record for executive orders?
I'm going to guess Lincoln?
No.
No?
No, it wasn't Lincoln.
No, okay. Tell me.
So this is in the 19th century, right?
No, 20th century too. I was trying, when I said modern times, I was saying, let's say from
FDR?
Oh, it has to be
FDR broke the record of all times. Okay.
Well, he was in office forever.
Yeah. Yes. So he had and it was wartime, so he had over 3,000. Let me see here. 3,725.
Jeez.
An average of 307.
And his opponents thought he was very dictatorial.
Yeah, right. But prior to that, for a number of times, for a number of years, there were few instances where more than 200 executive orders were issued by any one president.
But how are they constitutional? I mean, I don't understand.
No, but let me get to this because you surprised me.
It seems like one dude passing a law, right?
Yeah. Who was the first president to break the 1,000 benchmark? Let me put that.
Ooh. Jefferson.
No. Teddy Roosevelt.
It was Teddy Roosevelt.
Yeah.
That's not surprising. Yeah. I mean, you think of his temperament, you think.
Right. And he used it mostly for conservation and the national parks, that kind of stuff. But also
but he was also very popular. He had a compliant Congress for the most part. I mean, I just don't see. I mean, again, I guess I just don't see in the Constitution where executive orders come from.
No, but again, it's the executive branch, right? And they have the ability to issue orders that follow the law, the enactment of a particular law or a particular power that is conferred upon the president.
Or you could try to overturn an entire amendment to the Constitution with a stroke of a pen.
You could try to, but then that's why you have judicial review to basically determine whether that's constitutional or not. Now, Obama used executive power quite effectively for the Obamacare legislation et cetera, which of course was challenged a number of times
Well, I mean, Obamacare passed through Congress. It was a bill.
Yeah, but there were certain things, for example, taxes and how Medicare costs were sort of wrapped into that, and a number of things that Obama did that were challenged and went all the way to the Supreme Court, and the challenge lost in it, right? But again, if your executive order is within the bounds of the specific law or constitutional provision that you're basing on, all you're doing is acting as the executive, right? You are giving orders to particularly.
I mean, I see the validity of, like, okay, if you're clarifying policy, or you're just saying within the bounds, this is how we're going to execute this law or that law. I get that. But, what we've seen in recent years is really it's legislation.
Sure, absolutely. We saw it with the student loan under Biden, right?
Yeah,
that was done by executive orders, and it was challenged in court. And again, and people attribute this to the dysfunction of Congress, right? Congress is unable to get together on certain things, therefore the executive branch is stepping in to try to legislate on behalf of Congress. And I think there's a lot of that going around. I absolutely think there's a lot of that going around.
Well, when we invited you on the show, we promised we'd keep you only 30 minutes. We've lied about that.
Oh, wow.
Like a politician.
But I do have, one of the reasons I wanted to have you on, Ricardo, is that off mic, we've talked about the future and where we are as a country and where we're headed. The last couple of podcasts, I have to admit, Ted and I have been dour, to say the least, about the future and so on. You have been optimistic, and can we, if you could leave us with some optimism, that would be super duper, because and rare for this podcast recently. But it just seems to me that there seems to be a full-throated assault on the Constitution, on political norms, and I don't see us recovering in 4 years from this. That if you have a Solicitor General, for instance, more specific to our discussion, say that he may or may not, the administration may or may not adhere to a universal injunction, that's chilling, and it's supposed to be. If I had to read the tea leaves correctly, and I think I am. Where's your optimism coming from? And are you insane?
Yes.
You know it, right?
My wife can attest to the fact that I am insane. No, look, I have great faith in our institutions. They are under assault. Tradition is under assault. Norms are under assault. And by the way, from all parties, one of the things that upset me the most, there are two things from the Obama administration that offended me. One was Obama being a constitutional lawyer and professor, criticizing and taking away the legitimacy of Supreme Court decisions when they went against them, right? Rather than saying, I disagree with that decision, it was like, they're absolutely wrong, and the only way they decided that is because of politics. I think it's wrong for a president at that level to do that, because it takes away from the credibility that we as voters give the institution. The second one was from Obama, and sort of related, when Eric Holder testified before Congress about the targeted attacks overseas of terrorists and killing them, right? Ordering their death. And he justified it, as being a clear and present danger, and the administration had the ability to order their extrajudicial execution. And they followed up with a question, well, if that individual is an American citizen, overseas. And his response was, yes, we're still justified, which is chilling it to itself. But after the hearing, one of the congressmen followed up with a written question. What if a U.S. citizen on U.S. soil?
Yeah.
I remember.
Yeah, remember that? And his reply was, yes, we're still justified, which is absolutely chilling. And there were few, I think Tribe was one of the few constitutional scholars that raised his voice, but most were silent on this. It's like, what? You know, you are basically throwing away the entire process, judicial process, to arrest somebody and put them before a court and declare them guilty, right? So that's been happening on both sides of the aisle, so to speak. But I still believe that as a country, as a whole, we have very strong institutions. They will survive the attack, all right? I think we will find a more level approach to these things eventually, right? We're in for a very hectic 2 or 3 years with a lot of these things going before the Supreme Court and a lot of arguments going back and forth. But having come and having grown up in a totalitarian regime and seeing how that really works, I just don't see the U.S., the populace in the U.S. capitulating to the level they would have to capitulate in terms of the voters, in terms of the armed forces, in terms of the courts, capitulating to the point that we would not survive.
Okay. On that note, we will let you go. This was Ricardo Aparicio, and the bars of Alabama and Florida, also the U.S. Supreme Court bar, of which he was inducted recently. If you want to contact Ricardo, go to Aparicio Professional Advisors, LLC. You have a webpage or something?
Yeah, I do.
An OnlyFans, something?
And LinkedIn. You can find me.
And he's providing consulting.
That may be next, though.
Well, you do what you got to do. He's providing consulting services for real estate and construction industries. Ricardo, thank you for taking the time. I really appreciate it.
Thank you so much.
And Scott, thank you.
It's a real pleasure.
Take care.
Back anytime.
Take care. Bye-bye.
Bye.
Okay.
Okay, I think that wraps it up. I think we had a robust conversation. And also, I mean, that was the thing. Ricardo lived near here. Every few Sundays, go over there and have a cigar and a little bit of rum and just talk. And I got to tell you, 90% of the time he was just telling me stuff and I had no idea about. So I was probably the best informed editorial cartoonist in the country for that short period of time when I had access to Ricardo on a fairly regular basis. Because I'd walk over there and I really would, Ted, just go, what the hell does this mean? And he'd lay it out, and he'd lay it out in like, this is what's going on.
Yeah, I love how he does that. It's like boom, 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 boom. Yeah.
Yeah. Not versus
so easy a cartoonist can understand it.
Indeed. Well, I'm glad you're back. Why don't we wrap things up now, and we will. Is that okay?
That sounds fine.
Yeah, because you're still unpacking.
Yes, that's true. Thanks everyone for joining us. Check us out. Please hit the subscribe button. Please hit like button. Please share us on your social media and with your friends. Very important. Also a reminder of my new book, What's Left. Never mind the Democrats. Here's what's left. It's just like what it sounds like. It defines what the left is and what it should ask for going forward and outside of the Democratic Party.
It's awesome, by the way. It's a really good book. If you're concerned or interested at all in the future of the left in the United States, that you have to read this book.
And there's no future for the United States itself without a left, I think.
Oh, of course.
Anyway, all right, we're out of here as usual. Scott Stantis does the vocals in the closing credits.
I can't do Celia Cruz because that's again Ricardo turned me on to so Azúcar. There we go. That's as close as you're ever going to get to Scott Stantis imitating Celia Cruz. But thank you all. Thank you again, Ricardo, Ted. Thanks again. And until next time.